Alright, Title 40 CFR Chapter 1, 79119 edition, Subpart F, Part 22, Appeals from Review of Interlocutory Orders or Rulings. Request for the interlocutory appeal with the appeal of the other orders of the rulings other than the initial decision shall be allowed only with the discretion of the Environmental Appeals Board with the party seeking interlocutory appeals such of the order of the rules of the Environmental Appeal Board shall file with a motion within 10 days to serve the order of the ruling requesting the presiding officer forward an order ruling of the Environmental Appeals Board with a review of the stating briefly with the ground of the appeal. Availability of the interlocutory appeal for the presiding officer may recommend any of the order ruling of the review by the Environmental Appeals Board with the order ruling involved with important question of the law policy concerned with which the substantial ground of the difference for the opinion of if the immediate appeal for the order of the ruling of the materially with the evidence advances the ultimate determination proceeding with the review after the final order is issued the inadequate with the ineffective of the interlocutory review if the presiding officer recommended a review of the Environmental Appeals Board will determine the interlocutory review of the appropriate but takes no action within 30 days of the presiding officer's recommendation of the appeal will dismiss the presiding officer decline with the recommended review and an order of the ruling that may be to review with the Environmental Appeals only upon the appeal of the initial decision, except for the Environmental Appeals over the determined upon the motion of the part of the exemption circumstances deny delay review would be contrary to the public interest. Such motion shall be filed within 10 days of service of the order of the presiding officer refusing to recommend such an order ruling for the interlocutory review. Appeal from the review of the initial decision. Note of the appeal of the brief of the filing of the appeal with the filing of a deadline and who may appeal within 30 days after the initial decision. Approve of the name of the party with the appeal of any of the adverse order ruling of the presiding officer. Filing requirements. Appeal application must file with the notice of the appeal of the accompanying with the brief of the appeal the brief of the Environmental Appeals Board set forth in Title 22.5a. One copy of the document will be filed with the clerk of the board. Also serve with the headquarters of the regional hearing clerk as an appropriate with the appellant shall serve with a copy of the notice of the appeal upon the presiding officer of the appeal and shall simultaneously serve the one copy of the notice of the brief upon all the parties of the non-party participant. Content the notice of the appeal with the summary of the order of the ruling of the part of the appeal of the appeal briefly shall contain with the table of content of the authority of the appropriate page reference the statement of the issues presented with the brief of the review of the shape of the nature of the case for the facts of the relevant issue presented with the review of the specific citation, other appropriate reference for the record would include the document with the name and the page number of the argument issue, presented with a short conclusion stating precise relief sought with the alternative finding in fact with the alternative conclusions regarding the issue of law of the discretion if the repellent include the attachment of the notice of the appeal, an appealment brief, the notice of the appeal, and an appealment brief shall contain with the table of the provides the title of each of the appended documents for the sign with the label identified with which may be found in the record. Multiple appeals. Timely notes of the appeal with the file with the party, but any of the other party may file with the notice of the appeal with accompanying the appealated brief on the issue within 20 days after the date of which the first notice of the appeal was served within the time of the appeal within paragraph 811 of the section whichever the period ends later. Response brief. Within 20 days of the service of the notice of the appeal of the brief of the under paragraph A1 of the section of the another party, the no party participant may file with the Environmental Appeal Board's original one copy of the response brief with the arguments raised of the appeal with together the specific citation and other appropriate reference to record initial decision opposing brief including the document's name and the page number of the appealer shall simultaneously serve with one of the competent respond with the brief of the problem with the party, the non-party with the participant. The regional hearing clerk shall respond with the brief shall be limited to the scope of the appeal with the brief of the respond with the party with the non-party participants include with the attachment to do with the response brief. The response brief shall contain the table of the contents provided with the title of each of the document assigned with a label identifying where to be the file with the record with the further the brief that may be filed with the leave of the Environmental Appeals Board length of the briefs unless otherwise or with the Environmental Appeal Board's appeal with the respond with the brief not exceeding 14,000 words and with all of the briefs not exceeding 7,000 words. Filers may rely on the word processing system either determine the word count with the all alternative of this limitation filter for the comply with the 30-page limit of the appealated response brief and a 15-page limit for replies. Headline footnotes of the quotation on count the tour of the word limitation table of contents, table of authority, table of attachments, if any of the statement requesting the oral arguments, and if any of the statement complying with the word limitation, any of the attachments that do not count over the word page length limitation. Environmental Appeals Board may include an appeal with the response with the other brief that does not intend with the word page length limitation when a party can demonstrate with the compelling with the document needed to exceed the limitation. Such party that must seek advance leave the Environmental Appeals Board such to file a longer brief such as a request to errand or discourage and will be granted under unusual circumstances. Alright, 2. Motions. Unless otherwise ordered by the Environmental Appeals Board, the motion A with the response reply within the next 7,000 word filers, but to rely on the word processing counting system. You've determined the word count with the alternative of the word limitation. Filers must comply with a 15-page limit, a heading, a footnote with quotation count, or with the word and page length limitation. Environmental appeal may exclude whether any of the motion does not meet the word or limitation, where the party can demonstrate with the compelling of the document not exceed the limitation. Such party must seek with advance leave to the Environmental Appeal Board. Such request is discouraged and will be granted only in unusual circumstances. The review initiated with the Environmental Appeals Board. Whether the Environmental Appeals Board determined the review of the initial decision so only an issue with the shall issue the order notifying with the party of the presiding officer in intent with the review of the decision of the clerk of the board shall serve with the order with the regional hearing of the clerk presiding officer the party within 45 days of the initial decision served upon with the parties in order to later order with the Environmental Appeal Board identifying any of the issues brief time of the parties of the established time schedule following service over the brief scope of the review appeal or review of the paragraph and patient parties rights over the appeal shall be limited to those for the issue raised during the course of the proceeding of the initial decision issue concerning the subject of the matter of the jurisdiction Environmental Appeal Board determines the issue of the raised with the non-appeal by the parties shall be argued within such a give the parties written notice of the determination allowed with the preparation of the adequate arrangement of the Environmental Appeals Board may remain case for the presiding officer further proceeding. The argument before the Environmental Appeal Board, Environmental Appeals Board may in discretion respond to the request with its own initiative, order or argument, and any all issues proceeding with the request of the oral argument, the present party with the may exclude with the substantive of the brief of the sub-statement and with explaining with the oral agreement necessary with the Environmental Appeal Boards may in order to establish additional procedure for the governing and oral agreement with the Environmental Appeals Board. Are your motions on appeal? Generally, all of the motions during the course of the appeal shall confirm with the 2216 unless otherwise provided with advance of the filing with the motion with the party with the may attempt to certain wherever the other parties is and concur with the object of the motion must indicate with the motion with the attempt that made with the response with the obtain with the disposition with the procedural order of the environmental appeals may act on the motion with the as a procedural order anytime without the waiting of the response. Timing of the motion extension of the time. The patient must file the motion for the extension of the time sufficiently in advance for the due date, but allow the other party with a reasonable opportunity to respond to the request more time with the provide with the Environmental Appeal Board's reasonable opportunity to issue the order of decision. The Environmental Appeal Boards shall adopt, modify, and set aside with the finding of the factual in conclusion with the law of the discretion contained in the decision order to be reviewed shall set forth the final order of the reason of the action of the evidence. Environmental Appeal Board may assess the penalty and higher or lower the amount of the recommended to be assessed of the decision ordered by the reviewed from the amount sought with the complaint, but except that if the order has been reviewed and the default of the Environmental Appeal Board may not increase the amount of the penalty above the proposed complaint with the movement of the default, which if left, the Environmental Appeal Board may adopt, modify, certified, or recommended compliant with the correct action of the permanent action with the Environmental Appeal Board may remand the case for the presiding officer for further action. Subpart G, final order. Testing.